I'll be letting a few people in from the waiting room as we get started here. Good afternoon, everyone, and thank you for joining our webinar today. This is the fourth webinar in our series of conversations about changes to the Canadian Environmental Protection Act to protect vulnerable populations from hazardous chemicals. The title of today's sessions is Are Canada's Environmental Laws Up to the Challenge? Protecting Communities, Their Rights, and the Environment from the Threats of Biotechnology. My name is April Wepler, and I'm the Engagement Coordinator for the Healthy Great Lakes Program at the Canadian Environmental Law Association, or CELA. So I'll start with just a short land acknowledgement. I'm calling in today from Guelph, which is situated on the ancestral homelands of the Anishinaabe peoples, specifically the territory of the Mississaugas of the Credit First Nation and the Six Nations of the Grand Watershed. I should also tell you a little bit about CELA for those who might not know us. The Canadian Environmental Law Association, or CELA, is a specialty legal clinic within the Ontario-wide network of clinics funded by Legal Aid Ontario. And we work to protect human health and our environment by seeking justice for those harmed by pollution and working to change policies to prevent such problems in the first place. As a legal aid clinic, our top priority is to represent low-income individuals and communities and to speak up for those with less influence and who receive less of a say in decision-making. And if you notice me looking back and forth while I'm speaking, I'm also letting people in from the waiting room while I'm talking. So if I appear distracted, my apologies. And we're pleased today to be co-hosting our session with Nature Canada. Nature Canada is one of the oldest national nature conservation charities in Canada. For 80 years, Nature Canada has helped protect over 110 million acres of parks and wildlife areas in Canada and countless species. Today, Nature Canada represents a network of over 100,000 members and supporters and more than 800 nature organizations. Nature Canada is engaging in the modernization of Cipa in order to protect the genetic integrity of wild species and ecosystems and to ensure that Indigenous people's rights are respected. And Mark Butler, who is on the line with us and is Senior Advisor with Nature Canada, is leading this work for Nature Canada. I'll introduce all of our speakers in just a moment. But first, a quick bit of housekeeping for those who may be new to Zoom. We are hosting our session today as a Zoom meeting, which means you have a little bit more flexibility to engage with us in a conversation. But we're asking that you all keep your video cameras off and your lines muted during the presentations. We will have some time at the end for discussion. If we have any challenges with audio quality, I may have to mute some lines, but for the most part, people are learning Zoom quickly, so we are having fewer and fewer problems, knock on wood. We will be recording the entire session today, and we'll be sharing that recording on our website along with the slide decks from all the presenters. So you'll have access to all of those resources, and we'll email those around to everyone who registered as well. And the first 3 webinars in our series are also available on the website, and we'll post that link in the chat box in a moment. So we would encourage you to use the chat box throughout the session. You can say hi in the chat box now, let us know where you're from, and then pop the questions in as they arise. And as I said, we'll leave a good chunk of time towards the end of our presentation. Crystalline, can you move to the next slide so that people can see the agenda? Thank you. Great. So like I said, please feel free to use the chat box at any time. We're happy to hear from you. We will be answering most of those questions, as I said, in the discussion time after the presentations, and we may even have time to ask some of you to unmute and kind of elaborate on your questions. All right, I would like now to introduce our staff and our speakers. So on the line with me today, we have Faye. Faye de Leon is a researcher and paralegal with CELA, and she is also not only our meeting organizer today, but really the driver of this work at CELA. We also have Crystal Ann Roussel on the line. She is the articling student at CELA and is helping us with the tech today. So welcome and thank you, Crystal Ann. And then our speakers. We have Lucy Sherratt, who is the coordinator for the Canadian Biotechnology Action Network. She'll be our first speaker today, followed by Charlie Greg Sark, who is a professor at the University of Prince Edward Island. Then we'll hear from Elaine McDonald, who is a senior scientist with EcoJustice. And then Hugh Benavides, who is an advisor with Nature Canada. And as I mentioned, we also have Mark Butler, who is a senior advisor with Nature Canada, who will be participating in our discussion period at the end. All right, before I pass the mic over to Lucy to get us started, I just want to get a sense of who we have on the line with us today. So I'm going to show you a quick poll question here. So you should have a window that pops up on your screen with a question that asks what sector you represent. So if you can give us a sense of where you work, what sector you represent today. That would be great. Looks like we have about 50 people on the line with us today, so I'll give it a few more seconds for people to answer. Seeing some comments in the chat too about people coming in from BC, which is great. Welcome. Okay, let's share this back so you can all see where all of you are from. So we have most from non-governmental organizations and then a few academic students. We always have a bunch of other. We never capture all the categories. Feel free to tell us what kind of work you do or what sort of advocacy you're engaged in the chat box if you'd like to. And then the next thing we would love to know from you is what watershed you are located in. It's a little pop quiz for you if you know your watershed. And if you don't, we have an unsure category. And then of course we also have an other because we know not everyone is in the Great Lakes region. And we'll give that just a couple more seconds. And I will show that result back with you. So interesting, the vast majority of people, not vast majority perhaps, but half the people on the call today are not within the Great Lakes watershed. So we have 20 people from other. I'd love to hear where everyone's from. Other provinces, I assume. And then we have 10 from Lake Ontario, a couple from Lake Huron and the St. Lawrence River watershed. That's great. Thank you for that. So helpful to know where we have people attending from. And then the last thing we want to ask is just how you would rate your knowledge about our webinar topic today. So just a little self-assessment to give our speakers a sense of kind of the knowledge level of people on the call. All right, we'll share this back so you can all see. This is what we often find is most people saying somewhat knowledgeable, but clearly also an area where we have a lot of room for learning today, which is great. Thank you everyone for participating in those polls. And with that, I think, Crystal Ann, we can stop sharing this slide deck and let Lucy go ahead and share her slide deck.
Great, thank you. Great, you can see the first slide.
Not quite yet, it might just be taking a moment to come up. You want to try again? Not seeing it yet.
No?
Nope, not yet. And if it's not going to cooperate, Crystal Ann can put it up.
Okay, great.
Crystal Ann, do you want to go ahead and share Lucy's slide deck, please? There we go. Thank you. Go ahead, Lucy.
Well, I've actually sort of lost access to my window to see what you're seeing, which is a bit of a problem.
Right now, we just have your title slide up that shows the CBAN logo.
Yeah, maybe what I'll do is just say next. I can't see what's happening, but I know you're on the first slide. So if you can move to the second slide, I just wanted to introduce the Canadian Biotechnology Action Network. The second slide is CBAN member groups. And here's the list because we are a diverse network of 16 organizations, including farmer associations, environmental groups, and social justice groups. And I wanted to introduce CBAN in this way to also introduce the issue of genetic engineering or the scope of issues that are raised by the use of genetic engineering in food and farming. The next slide, please. Because we do see that the use of genetic engineering can have an impact in our seeking food sovereignty and environmental justice. Next slide. And the genetic engineering that's in front of us, of course, is these crop plants. In Canada and around the world, the experience we have is with genetically engineered, we could call them genetically modified crop plants. And this pie chart is a chart of what's on the market now, what's in the ground now. And the next slide shows the table of the GM foods on the market in Canada. And you will see here, number 6 is this Atlantic salmon that since 2017, some shipments have come to Canada, not to any other country, from a small plant in Panama, an on-land facility. So this is the first genetically engineered food animal in the world. And it's one of the reasons why the discussion around the Canadian Environmental Protection Act is so relevant, because it does regulate genetically engineered animals as opposed to the crop plants, which have been regulated by the Canadian Food Inspection Agency and Health Canada. If we go to the next slide, this is the little pig that symbolizes the EnviroPig. So the first genetically engineered product that was regulated under Cipa was this genetically engineered pig, which would have been the first genetically engineered food animal, but the pork producers decided it was not wise to commercialize it. And the next slide is just a signal that this first GM food animal on the market is this genetically engineered Atlantic salmon. And we can talk about some of the critiques we had around the regulation, but I just wanted to say that the regulation of the genetically engineered pig is distinguished from that happened for the Atlantic salmon, because for aquatic organisms of biotechnology, there's a memorandum of understanding. That means the Department of Fisheries and Oceans is involved in the risk assessment of aquatic organisms. And this meant that under that memorandum, there was a different process involved, a little more transparency, a little more engagement. The next slide just shows what this actually looks like. If we're talking about production of genetically modified salmon, this is the photo that AquaBounty, the company, provides from Prince Edward Island. And the next 2 slides show the actual facility itself in Prince Edward Island. The first quote unquote harvest from this facility is due any day. It is delayed. It was expected by the company in early January. So the next slide just indicates that CBAN has documented the contamination and escape incidents with genetically engineered organisms to date. These are living organisms and they present unique environmental challenges. These contamination incidents, as it happens, had more social and economic impacts rather than environmental. But it tells us that even with containment, such as we saw in AquaBounty's facility in Prince Edward Island, through those photos, there's always a risk. Things that we do not expect to happen will happen. And in fact, a major source of contamination is human error. The next slide is to indicate that we are likely to see more genetically engineered animals being put forward for assessment. And this is partly due to the new genetic engineering techniques of genome editing or gene editing. And it's particularly important just to mention these because the media is talking about this technology all the time, and the industry would like us to view these techniques as less risky, producing organisms that are less of a concern. And we argue this is not the case. Certainly the science does not allow for that conclusion. And we have a report here that documents that. And just to point forward, the next slide introduces one of the applications of genome editing is gene drives. This introduction of a mechanism through an organism that can permanently modify or eliminate entire populations in the wild. So with genetically engineered animals or insects, we are moving from an application of genetic engineering in an agricultural context to one that is in the wild. And the following slide points to the fact that this is not far-fetched, that there already is a request to approve a genetically engineered tree, an American chestnut tree, in the US. This request is also anticipated in Canada. This is for planting into the wild. So certainly there's the issue of Cipa's regulation of genetically engineered animals for food consumption that may be produced in an agricultural context, but then also these genetically engineered organisms that would be produced explicitly to release into the wild. Thank you.
Thanks very much, Lucy. It was a great overview and introduction to the topic. All right, so Charlie, you could unmute yourself and start your video. I know you don't have slides today, so we just get to look at your lovely face.
Thanks. I have an old-fashioned slide behind me where
Perfect.
some of my thoughts. My name is Charlie Greg Sark. I'm a member of the Lennox Island First Nation, which is in the Malpeque Bay watershed in Epiquid, or also known as Prince Edward Island. And I'm an assistant professor at the School of Climate Change and Adaptation at UPEI. And today, if I had a slide up, I'm considering altering sacred animals, redesigning genetics for profit at the expense of rights and environmental integrity. I'm just going to cut and paste that into my the chat box for you in case people want to be reminded of what I'm talking about. So we'll just do that right now. There's the title. It's on my board behind me. So for me, the issue that's in front of us today is ultimately an issue of anthropogenic climate change. The human experiment has existed really in a natural world where changes have more or less been occurred over the long term. But we're now seeing is this anthropogenic push with interventions that are forcing significant, immediate and abrupt changes on us without a couple of things, I believe, really understanding those impacts, the knowledge behind them, and for some people without their consent. And we really fully comprehend how these abrupt changes will affect us, or just how precarious they are until it's too late. And this is includes our genetic identity and those of our close relatives, such as the salmon. So I'm going to look at the issues briefly here. I encourage people to explore this idea further in the concept of Indigenous people's rights. This isn't a law presentation. I'm not a lawyer, don't have a law degree, but I'd like to present the Indigenous people's perspective here, specifically Mi'kmaq, the nation I'm from, and considering that this plant is within our territory without our consent. First of all, from an Indigenous people's perspective and rights, there's really no containment plan that is infallible because human error is there, human error in the form of greed. And so things will escape. And the premise of this genetically modified salmon is that it'll be contained. But my question is, what happens if the salmon that's altered, gets out into creation? It's kind of like Alco Bounty, the company, has applied to Canadian settler colonial law systems in an effort to own the animal that they're genetically modifying. Now, this raises questions for me because I have a right to fish as opposed to a privilege to fish, which is buying a license. I have inherent treaty rights that are also enshrined and protected under the Constitution and other declarations to go fishing. We also, by fishing, I also participate in a culture and economy and in ceremony, including language, words, expression, family lineages. Other nations across what we call Turtle Island have even more intimate relationships with the salmon and different types of relationships with the salmon and consider them family. And these laws weren't considered, to my knowledge, in the process of approving this GMO salmon. So my question really is, can a settler nation company, in step with settler nation jurisdictions, alter the genetic identity of an animal? Specifically, can they do this without considering the rights of Indigenous people? And I can't find anywhere where the federal government or the company in this case have considered the United Nations Declaration on the Rights of Indigenous People, specifically something referred to as FPIC, which is an acronym for the Free, Prior, and Informed Consent of Indigenous People. So this is tantamount to just ignoring the fact that the Mi'kmaq have a relationship that goes back thousands of years with an animal that they've used for ceremonial purposes and for food purposes, and also it's part of the political economy for us. I just, on that note, one of the things I think we should consider is this is not just a legal question, but I consider it a question of honor and ethics, that being the honor of the crown and the ethics of the private business interests. And I want to talk about climate change for a little bit here, because in addition to changing the genetics of an animal, which is altering the climate, essentially, we're also going to consider the modern processes involved in this economy when it comes to climate change. And so transportation networks, just so some of you know, the fastest growing, but transportation has some of the fastest growing CO2 emissions. And without any sort of mitigation measures, which we're really not seeing a lot of being proposed, transportation will grow by 60% by 2050. Freight volumes alone are going to triple by 2050. And this is important to consider in the context of farm fish, because the emissions related to harvesting, processing, and transportation of feed inputs, as well as the finished product, involve air transport primarily. And also on the feed side, the mix for feed for farmed salmon is predominantly wild fish caught. And so that's another concern I'll get into a second here on food security, but this stuff involves transportation, and the farmed fish is not typically being farmed within the jurisdiction that it's being marketed and sold into, which creates issues around transportation again. My last point I'd like to focus on is a food security concern. This is really the nexus of my personal research and teachings at UPEI from a Mi'kmaq and other Indigenous peoples' perspective. And like I said, the markets for salmon are in regions of the world that don't necessarily experience high rates of food insecurity or severe food insecurity. The countries that consume farmed salmon and the segments of the populations inside of those countries have a privilege in the form of currency to purchase salmon, and it represents a small segment of the world's population. What does that mean in security perspective? Well, farmed salmon feeds populations that are already overnourished, generally speaking. In fact, this requires more analysis, but it's plausible that there is a caloric redistribution, for example, of wild-caught fish to feed farmed fish, to feed overnourished populations, as opposed to addressing the concerns of food insecure and severe food insecure countries. For example, the markets for farm fish tend to be Europe, North America, Japan, Russia, countries with a high GDP, but also with the wealth and the privilege that afford them the ability to make a choice on what type of animal protein they consume. I haven't seen very much of this wild salmon being brought to countries such as sub-Saharan Africa, where the food insecurity is extreme. In fact, again, are the wild fish that's being fed into these farm systems, where is that originating? Is there a caloric, are there calories being exported to grow fish to feed overnourished populations at the expense of undernourished populations? So it's some research and some questions I think we need to consider. So essentially, the questions or my concerns, to sum up, is who owns the GMO salmon? If I go down to the river 2 years from now with my cousins and we pull a salmon out of the water, and DFO, who loves to follow us around and harass us when we're exercising our rights, finds that the salmon we have is GMO salmon owned by Aqua Bounty, what happens to us? there's also, I mean, that's to me genetic pollution, and it impacts my rights. And also, I'm curious, and I throw this out there: has the Indigenous experience in Canada been considered by Aqua Bounty and the government of Canada? And where is their moral response and legal responsibility to obtain our free, prior, and informed consent? I haven't seen it. I would love to be proven wrong, but I'll wait to see. And the final thing is just how, because I've seen it alluded to in literature on farm fish. I'd like to understand what is the plan in terms of using enhanced salmon, in this sense, genetic modified salmon that grows faster. How is that going to be applied to meet the world's food insecurity that continues to rise and increase with the impacts of climate change? And we're facing a significant food gap in the next 30 years if we don't address climate change issues and the redistribution of nourishment or calories in the global population. So is this reasonable to consider overnourished and undernourished areas of the world in the context of genetically modifying animals, if those animals aren't really going to the nations and the areas and the people that would benefit from that food source? So I think that's everything I have to say. Thank you for your time. Well,
Thank you very much, Charlie. Those are some complex but really critical questions, and I'm sure everyone will want to dive into those in our Q&A at the end. So if that brought up questions for you, please feel free to pop them in the chat. I know a few people have done so, but feel free so you don't forget them in the next 20 minutes or so. All right, thank you, Charlie. I'm going to pass it now to Elaine. Elaine, do you want to go ahead and share your slide deck?
Yes, that hopefully it works. Let's see. Is it working?
Looks great.
Good, fabulous. Okay. Sorry if I'm kind of turning my head because my slide deck is on my other screen. And I apologize for that. But anyways, so I am going to get a little bit more into kind of the Cipa and what Cipa needs to kind of help address this issue. Just to introduce myself, I'm the director of the Healthy Communities program. I'm also a senior scientist, so I kind of wear two hats, and at EcoJustice. And thanks for having me. Okay, I want to give a bit of background on the, oops, I did not mean to advance twice. There, is that good? I want to give a bit of background on the Cipa reform mandate, Canadian Environmental Protection Act mandate. Back in 2016, 15, actually, it started. The Standing Committee, Environment and Sustainable Development, launched into a review of Cipa. It was quite a comprehensive review, went on for 15 months. They heard from like a number of witnesses, 56 witnesses. After that 15-month review, they did come out with 87 recommendations, and some of them, only a few of them, I must say, did touch on the issue of biotechnology and how it is assessed and regulated under Cipa, which is an area of Cipa we refer to as Part 6. Cipa is a very comprehensive act, as anyone can tell you. It's got, I think, 12 parts and 300 odd sections, so it is quite all-encompassing, but there is a section that does deal with the regulation of biotechnology. Coming out of that review, there was recommendations from the committee for up to 87 recommendations for reforming Cipa, and in 2019, in the mandate letters to the Minister of Health and Environment and Climate Change, we did see a mandate to introduce a bill to reform Cipa. And then in September 2020, that was reaffirmed in the speech from the throne. So that's kind of where we are with respect to reforming the Canadian Environmental Protection Act. The picture I have on the side is just the cover of the NV report, which is available through their website if anybody wants to read it. And then with respect to recommendations that we put forward with a group with other NGOs, there was a long list of them dealing with many different aspects of Cipa, because Cipa regulates toxic substances. It relates to both the environment and human health. But with respect to genetically modified organisms or biotechnology, really that's the second last recommendation on this list, and it's about improving the review and approval process for new substances, including genetically modified organisms. And much of the issues with respect to new substances apply to chemicals and biotechnology, just to make that clear. And I will get into a little bit of the details now on some of those. what we learned about the problems in Part 6 really come from an experience we had in undertaking litigation with respect to the aqua bounty genetically modified salmon, aqua advantage as it's called. When the salmon was first approved, we did go to court to try to challenge the approval, and through that, and perhaps we would not have ended up in court trying to challenge that approval if Cipa had done a better job of assessing and regulating these salmon, but unfortunately we did end up in court. We weren't successful in challenging the approval, but we learned a lot about the issues and problems with Cipa in the process of undertaking that litigation. Unfortunately, the lawyers that were involved in that litigation are no longer at EcoJustice. It would be great to have them here today to discuss this, but you've got me instead. So I'm sloppy seconds, but hopefully can get to some of the meat of the problems that we've identified in the Canadian Environmental Protection Act. And as I said earlier, many of these same deficiencies, I say, would also apply to any new chemicals that come into Canada. They're a little more serious when you're talking about genetically modified organisms, given that genetically modified organisms potentially could escape and reproduce in the wild, where you don't get that with chemicals, but it's a lot of the same concerns. So what we did learn, first of all, there is no, and I know Hugh will be getting into some of these a little bit later in his presentation, so I'm just going to touch on them. But Cipa, when there's with respect to genetically modified organisms, there's no notification or consultation requirements. So the public has no way of knowing that a new a application to introduce a genetically modified organism in Canada has been submitted to the government, because there's no public notification requirement. And of course, with no public notification requirement, there is also no public comment requirement. So right off the top, I think one of the strongest amendments that could be made to Cipa is to integrate these into the Act, so that there is notification as well as consultations with respect to new genetically modified organisms. And I think that would be the bare minimum, really, that would be needed to. I mean, probably need to go beyond just that, but as a start anyways, consultations and notifications. The other issue that came up is with respect to this thing called waivers that occurs under Cipa, and it's a little bit technical, but what I can explain is that when a company does want to bring a new genetically modified organism or a chemical for that matter into Canada, they do have to provide the Canadian government with quite a bit of information and data. However, the Canadian government can waive certain data requirements. And in the case of genetically modified salmon, they did waive some data with respect to invasiveness of the salmon, because they assumed that the salmon would be contained within the facility and not escape. There went through the process of the approval of the Aqua Advantage salmon, that information about waiving was supposed to be published in something called the Canada Gazette, which is kind of like the federal government's reporting out on decision making and so on that they make. However, they did not publish that in a timely manner. And in addition, the form in which the information they publish is very minimal and unintelligible for somebody to actually understand what the government has done. In fact, the publishing of this information is probably the only way anyone knows that something is happening with respect to this salmon, but yet it is so unintelligible, it's hard for anyone to comprehend it, truly understand what's going on. So one other recommendation is that there be timely notification of any data requirements being waived with respect to a genetically modified organism, and that information be intelligible and complete, such as include the name of the company that the information was waived for, the name of the living organism, and what kind of scientific data has been waived, and that the waiver really only come into effect the day it was published. In the case of Aqua Advantage salmon, there was a major gap of time between when the waiver was actually provided to the company and when it was published. And that the waiver make it clear that no person shall use or manufacture or import the organism unless it is for the purpose prescribed in the initial notification. There's also something called significant new activity notices that occurs under Cipa, and these are notices that really, if it's attached to a certain substance or a genetically modified organism, it really triggers a requirement that if you are to use that substance or organism in a different way than the initial notification, that you have to go through the whole process of approval again. So it's like starting from square one again. And these notices are also have been really problematic in terms of the information they provide. So our recommendation with respect to those notices that they require the notice of a new activity triggers a public notification and consultation again. So they have to start out so the public knows that there's been a new notification with that substance. and provide clear rules under which circumstances the right to introduce a new substance is transferable. And the reason we've made that recommendation is because when the original significant new activity notice was published with respect to the genetically modified salmon, on its face it appeared like it could be transferable to another company other than Aqua Bounty, which was a really big concern that the other companies could basically use that to have the right to manufacture. That hasn't panned out, but it was something that did bring to our attention that we need clarity in the Act with respect to what those notices and how they restrict the use of the substance that they're attached to, or the genetic organism they're attached to. So what are we hearing with respect to these recommendations? Well, our discussions with government to date have not been very encouraging. With respect to public consultation and notification, we're hearing that there's concerns about confidential business information, that companies don't want to have consultation and notification because that might expose their confidential business information. We also heard that the government is implementing these voluntary consultations for higher organisms, which of course is not acceptable or good enough because they're voluntary and they're only for higher organisms. So there's no guarantee that there will be consultation and how the company would have to agree to the consultation. We're also heard back from government that the timelines in the Act do not allow for enough time for consultation. The government is required to review the data provided by companies in a very quick time frame under Cipa. So there's limitations there in terms of providing consultation. All these things can be fixed, obviously, by amendments to Cipa. There's also provisions that allow the minister to expand the timelines if 120 days is enough to review the data that's provided. So really what we're hearing back is that when the bill is introduced, hopefully we get a Cipa bill, that Part 6 may only be getting tweaks and not a major overhaul, which is really what's needed. Just to highlight, to let people know what the latest is we're hearing on the timing of a bill, it's been pushed back a number of times, unfortunately, which is discouraging for us that have been working hard to try and get Cipa reform for a number of years. And the latest we've heard is hopefully this spring at some point we will have a bill to amend Cipa. So there's still hopes, I guess, that we can push for stronger amendments. And that's all I had. Thank you very much.
Thank you very much, Elaine. That was great. A lot of detail. You did that very efficiently.
Oh, stop sharing. There we go.
Perfect. Thank you. All right. So I will now pass the mic over to Hugh. Hugh, if you want to go ahead and share your screen. Perfect. Looks great.
All right. Thank you, April. And thanks so much to Lucy, Charlie, and Elaine for setting me up so well. And this is a pretty complicated and complex issue, including, not limited to, a lot of different terminology and as my colleagues have alluded to, there are many dimensions to this. So I look forward to the Q&A so we can get ourselves all better on the same page in response to any questions. I'm Hugh Benavides. I'm a lawyer working for Nature Canada as an advisor on this issue. And partly, I think, on the strength of the fact that when Cipa 1999, before it was a law, when it was a bill in Parliament, I worked with the chair at the time of the House of Commons Standing Committee that had put several years before that, in fact, into compiling what was needed for a new Canadian Environmental Protection Act at the time. And later I was a lawyer at CELA working with Faye and others representing CELA in the legislative review of Cipa 15 years or so ago. And one of the reasons I mention that is that while a lot of consideration went into what should go in the law and then reviewing the law later, Part 6, which is called Animate Products of Biotechnology, Part 6 of Cipa has really been somewhat neglected compared to the other parts of the Act. Meanwhile, we have, as others have said, fast-moving developments in the realm of biotechnology, including, of course, the world's first genetically engineered food animal, the AquAdvantage salmon, and more challenges, as Lucy has previewed, are certain to arise. The question is, can Cipa keep up? And I would suggest that the time is now to modernize and to reform Part 6 of Cipa. Looking again at the AquAdvantage salmon, or AAS, case that my friends have previewed for us, I just wanted to show this slide to reinforce how quickly the turnaround is in Cipa. And this is because Cipa says the prescribed assessment period is 120 days. That can be varied, but by and large, that's the default. And so that's why in April 2013, AquaBounty, the proponent of AquAdvantage salmon, notified, it's one of the key terms, notified Environment Canada of its proposal to manufacture this new living organism. That's also Cipa language, new living organism. And by August, just a few months later, the required science assessment had been complete, including, as Elaine has described, some of the information that was important. The AquaBounty asked to have that information waived. The waiver was granted, and the snack notice, another term that Elaine has described briefly, was published. The effect of that process, and the reason I show those 3 bullets, is that meant that in that short period of time, the proponent, AquaBounty, was able to proceed with what it wanted to do. Other problems exemplified by the AAS experience is that, again, as others have said, no public notice of the fact that a company has notified, which is basically an application, has issued its notification. There's no public notice of the company's request for a waiver. Picking up on another point, important one raised by Charlie, there's no consultation to obtain the free, prior, and informed consent of Indigenous peoples. And again, arising from the fact that there's no public notice, there's no public involvement in the science assessments that are required. I want also to highlight some hard truths about Cipa. The first is that Cipa has an exposure-based and a risk-based notion of hazard. And it's not just how Cipa considers the idea of what is toxic, but it's also how Cipa is implemented in combination with that notion of toxic. And so one example of that is that, as others have said, containment is, even though the substance, or in this case, the organism, can be considered toxic, if the company, as happened in the salmon case, can say, well, we're going to contain it, then the full implications of the fact that the organism may be considered toxic are not considered. Secondly, there's no public discussion of need for the new living organism or the public acceptability. We have a science assessment of risk, but that science assessment is not a forum for determining acceptance or acceptability. And third, the market rules in 2 ways. One is that 120-day clock. The rules are aligned with the notion that there's a rush, that these new products have to get to market, and to delay them would somehow be a threat to economic well-being. And the second way in which the market rules is that confidential business information, or CBI for short, is sacrosanct, and that nothing can be, that because it's sacrosanct, we have to protect that information, as Elaine alluded to. These are three hard truths about Cipa, and things that really, in order to have real change, need to be addressed. So a summary of the recommendations that Nature Canada, as a result of consultations with some of you on the line and other experts from across the country, a summary of the recommendations that we've come up with and have presented to the government are summarized. This is the summary here. The first is an overarching recommendation to uphold Indigenous rights, and including those articulated in the UN Declaration on the Rights of Indigenous Peoples. Secondly is that we support the recommendations developed by other groups, namely that list of 11 bullets that Elaine showed, and many of those dovetail and overlap and are mutually supportive with our main recommendations. Thirdly, we'd like to change the paradigm to the extent that should be a burden on the company or person who wants to introduce a new living organism. In other words, the manufacture or the import or the use of that organism ought to be prohibited unless and until the proponent can demonstrate its safety. And this is not a new notion for Cipa. These are things that we've been advocating for many years, but it's critical. Fourth, minimum timelines should be put in place to allow for consultation. Timelines should be a minimum. They should not be a clock for regulators to race against, which is the case now. Number 5, a notification, which is in effect the application or the request submitted by a proponent, submitted to the minister, should become public automatically. Similarly, their request that certain information be waived should be made public automatically. Next, the science assessment that happens currently, and the public consultation, which is an important thing that we are proposing happen as well. And I would suggest, especially for a new living organism with huge implications like the Aquadvantage salmon, for example, should trigger a requirement, not just for a public comments to be submitted, but a full-blown consultation to take place. Those two things have to involve the public. They have to allow for alternative views to be expressed, and there has to be a requirement for informed acceptance. And I say this in parallel and in addition to Indigenous consultation. And I would note also that Indigenous knowledge should be something that is implicated in the science assessment as well. And finally, these processes, both the science assessment and the public consultation, should take better account of the inherent hazards to nature of a new organism. For example, what are the implications of a new salmon species for its wild counterpart, Atlantic salmon? And so in conclusion, I would suggest that strengthening Part 6 of Cipa in these ways is much more likely to address than the current regime does the risks that new living organisms will pose to nature. And by that, I mean not just the wild counterparts that are threatened by the introduction of a new living organism, but also the ecosystems and the places we care about. In the case of Aquadvantage salmon, this is one of the ends of the road on the Cabot Trail in Cape Breton Island. This is a little place called Meat Cove that many of you have probably been to. And I think strengthening Part 6 of Cipa is also more likely to properly address Indigenous rights and public concerns, and give us an opportunity, and government and Canadians an opportunity to determine what is really in the public interest. How does the potential introduction of a new living organism affect nature? How does it affect ecosystems? How does it affect the long-term future that people want? And I think these are not too much to ask for a law that's made by our Parliament. And I look forward to the questions. So thank you so much.
Thank you very much, Hugh. That was great. Okay, we are at 10 to 2, so we have about 25 minutes left, almost 25 minutes in our time together, which is great. We've got a good chunk of time for some questions and answers, some discussion. So at this point, I think before we even put up our closing slide, which has a bunch of great links and some contact information, I would ask all of our speakers to put your cameras back on. You can unmute your mics as well if you don't have a lot of background noise. That way all of our participants can see you. So I would invite participants at this point to pop your questions into the chat. I pulled a couple out from earlier, but I'm going to give you a minute to kind of think about the presentations and get your questions into the chat. I know that takes a moment. And I guess I'll ask, while we're sort of waiting for people to do that, I would invite any of our presenters, or I know we also have Mark on the line, we also have Faye on the line, if anybody has kind of a concluding thought, an extra thought that came to you while others were presenting, or even a question to start us off while people put their questions in. Anything burning from anyone?
Well, this is Lucy. Maybe just because it follows from Hugh's concluding remarks, and I see there's a question from someone about how can the concept of need be incorporated. And just to say, you know, the policy decision that was made on genetic engineering was very clearly to leave the question of public interest for the market to decide. And the assessment was that genetic engineering would serve society as new high-tech innovation. And so the regulation it examines the question of safety, and then it is left for the market to decide. That is generally the policy and the structure of regulation. So, thank you.
I was just going to point out too that Caitlin Mitchell is on. She was one of the lawyers at she was at Ecojustice at the time that argued the Aqua Bounty case, and she has joined. She's now at Animal Justice. And I don't, Caitlin, if you want to turn on your camera and say hi, but she's offered to answer questions if anyone has any questions about the actual litigation, which is great. Thanks, Caitlin. I appreciate that. I can't do it justice.
Hi.
Hi.
Hey, Caitlin. That's a great question about need. And I would just, by analogy, I would point out that environmental impact assessment legislation and the notion of environmental assessment has long required a consideration of need. And it's an awkward thing for proponents and for governments to have to address it. And in fact, it's often not addressed as a result. And so I think that's a really interesting point that you make, Lucy. And so at a minimum, we should, in answer to an attempt to answer that question, we should require consideration of need, because after all, if we don't need something, you know, we need to put that question front and center.
Anyone else want to weigh in on that one? Okay. So I saw a question earlier in the chat box that was, at the base of GMO approval is the principle of substantial equivalency. And the question was, they don't understand how an organism with introduced DNA of another unrelated organism is considered a substantial equivalent to the original organism. So hoping somebody on the line with a whole lot more history in this than I do might have some insight on that.
Yeah, this is Lucy. So yes, from the outset of the regulation of genetically engineered foods and crop plants, this concept of substantial equivalence and familiarity, these were both used as guiding concepts for the risk assessment. And how it is used is obscure. We don't have access to the regulatory process. We don't know how that concept is used. None of that is available to the public, except that there's this generally a comparison between genetically engineered products and others. And so actually over time, it's possible, and this is what we're seeing and may see soon in new proposed changes to guidance and regulation, is that the benchmark for what is familiar keeps changing and moving. So now, after 20 years of genetically engineered crop plants, we are very quote unquote familiar in regulation with how they function and their potential risks. And so it means that over time, the scrutiny over genetically engineered organisms could become less rigorous because the comparator is now no longer a conventionally bred product, but another genetically engineered product. Or, you know, we are choosing, certainly the discourse generally says this, and Health Canada will soon release some draft guidance to change the definitions of genetic engineering. It seems that there is a choice to generally move towards more assumption rather than scientific assessment, we would say, without explaining that further on the concept.
Okay, thank you, Lucy. A couple other questions that have come into the chat. Let me scroll back. Bit of a more of a maybe campaign question, if anyone wants to weigh in, asking, is the government or the House Environment Committee open to any amendments being recommended? And then asking about the views of the various political parties as well.
I don't know if Mark wants to try and take that one, or
Sure, I'll start, and then Lucy and others can jump in. The government itself still seems to be remarkably impervious to making any substantive changes to Part 6 of this Act. And I think I posted in the chat, you know, to me, it's pretty incredible given the dramatic changes in this technology, and I think the dramatic implications it will have for every aspect of our lives over the next coming decades, that they are really only proposing housekeeping changes at this point. And I think it's partly because of the complexity of the issue, and maybe they just haven't heard enough from people. But you know, we've had no societal discussion about this issue at all at kind of a broad level, which the government should also initiate. The Bloc have been very active on this. It's an issue that seems to have more salience in Quebec. Petition just closed with about 4,500 signatures. Monique Posey will be presenting, and the Greens and the NDP have certainly been trying to get the government's attention on this. We've had some conversations with the Conservatives, but the short answer is they need to hear from more Canadians on this, and we're trying to build a loose coalition. So please get in touch if you're interested in joining us in amplifying the need to fix Part 6 and all of Cipa.
I'd just like to add something as well. This is Faye De Leon from CELA. And I think it's just the overall process. If we see a bill being introduced sometime in the spring, as interested public in these issues, I think we have to make it a priority to consider you know, making it a more open process for that engagement to continue when the bill is being reviewed. So, you know, some role that the public needs to play is not only to talk about the changes that need to be made to CEPA specifically on Part 6, but certainly to ensure that those voices are heard during that period of time. If this is, this is the first go at changing Cipa, that kind of practice was certainly evident when we were reviewing Cipa 1999. He will attest to that. So the role of the public is still quite important once the bill is released out to the public.
I just want to build on what others have said about public engagement as well and interests of political parties. I'm aware of several Indigenous organizations who have expressed concerns and in the recent future, or past, not now, but in the past, have signaled to the government that they had concerns over this, but to essentially no avail, in the sense of no response or no opportunity to intervene or to say anything, which leads me to believe, considering experiences and being familiar with how excuse me, the Canadian government approaches Indigenous people's rights in other issues, is that they're prepared for this to be decided in the courts, at least from an Indigenous people's perspective.
Thanks, Charlie. Did anyone else want to weigh in on that? Okay. I'm seeing another question in the chat that I can read out, but I'm guessing you're all skimming the questions as well. So is anyone seeing a question that they in particular want to respond to?
Yeah, maybe I can provide a quick clarification to the question that says, in our conversations with government, how is the government justifying a mere tweaking of the applicable sections? I suppose there are two elements to answering that. If I was the government, I would say we undertook, we had the House Environment Committee undertake a study, and we made a number of 80 some or 90 some recommendations, and the government responded to those. To vastly paint those with one brush, I would say that I found many of those recommendations or the government's intentions to be fairly unambitious. Some changes that they're proposing, yes. On part 6, their answers were pretty unsatisfactory and also fairly modest. And Mark and EcoJustice and Sela and others made comments about part 6, but the amount of proposals or attention paid to part 6, as I said, was less perhaps than part 5, which deals with toxic substances, for example. So it's partly a little bit of less attention was paid earlier, but that doesn't mean that the government doesn't know and the public doesn't know that we need to address part 6, and we perhaps need to continue to ramp up the attention on that. So the government would say, we've got a whole slate of changes to be made, and people can differ on how big or small those proposals are. Also, I just was rereading the Narwhal article that Mark pasted in the chat last night, and that article reported that very few changes to part 6 were being anticipated. And I have a sense that that's made the government a little bit sensitive to that criticism. So that's a little help for us that they may be now motivated to look at this more.
And Hugh, I would say that the recommendations from the Environment Committee, while not adequate or fully what we need, were reasonably good. And if the government had responded positively to all of those, we would be in a better place.
Yeah, thanks. I wanted to give that fuller picture that there was a study done over several months by the committee.
Yeah, I think in terms of the recommendations to the committee, if it really hadn't been for Mark and Caitlin, who are working on the ACO Bounty, and Lucy, who are working on the ACO Bounty situation at the time, had litigated it, I don't think there would have been any recommendations that had been submitted into the NB committee during their review. And really what the NB drew from were very much what had been provided with respect to the issues that were underway with respect to the Aqua Advantage salmon. So it is Hugh is right. It is unfortunate that more groups didn't wade in on part 6, join the ENVI review, and it was really kind of a missed opportunity, I guess. But at least those voices got in there.
Great, thank you. I don't want to stop the discussion yet, but I'm just going to ask Crystal Ann to put our closing slide up because it has a lot of these links that I think we're referencing and places to find some of these resources. So I'll just have her put that up in the background, but everyone can keep your video cameras on. We can keep taking questions.
Can I jump in here, April?
Go ahead, Mark.
Just to say, you know, I think Charlie spoke very eloquently about the importance of Indigenous rights, and this technology, and Nature Canada and other groups are working hard to engage with Indigenous nations across the country. So please reach out. We're trying to work with, yeah, as I said, with groups across the country, including in BC. Charlie, do you have any thoughts on the new UNDRIP bill and Cipa?
Yeah, I have lots of thoughts, Mark. But I'll try to keep it short then. It's hard to cover 500 years of colonization, which my response to UN DRIP would include. But the Coles Notes is, my fear is that inside of Bill C-15, I think it is, which is the UN DRIP bill, is that they're trying to box in Indigenous people's rights, inherent treaty or otherwise constitutional, trying to box those into a category or a way of defining Indigenous sovereignty, but within a Canadian colonial framework. And it sounds to me like, of what I'm seeing, that the rights framework that was floated around Ottawa years ago, Indigenous rights framework, which is really, again, I would interpret as a boxing in of rights from a Canadian colonial perspective. That's what's really being essentially pulled off the shelf, dust off, and presented as the new bill. That's my feeling of, or my take, and what I've heard from other people. But that's kind of where we are. I think there's an editorial. I shared my speaking notes, and so you can publish those if you're publishing the presentations. I saw someone ask for them in the chat, and in those notes, I linked to a article from a law firm, and it's quite a fun read because it uses this a Star Wars analogy of the dark side. And so some of you might have already read it. And I think that article pretty much nails it in terms of what Bill C-15 will probably look like or be to us. Essentially, a Southern nation colonial interpretation of Indigenous people's rights.
Thanks, Charlie. Yeah, we'll be sure to include that link on the website with the presentations, and we'll also include that in the email that we sent out. I just dropped all of the links that are on this slide right now, because I know you can't click on your screen. So those are all in the chat box. I think they are mostly self-explanatory. If anybody wants to comment on what some of those links are, feel free to jump in. But just in case we start losing people, because I know we're coming close to 2:15, there's a webinar evaluation survey, and this is an opportunity not only to kind of comment on today's webinar and give us some feedback, but there's also a chance there to give us your name and email address and indicate that you want to stay engaged in this discussion. Faye has also put her email address and phone number there. So, you will get a follow-up email from us with all the links from today, but it's also a chance to just say we really want to stay engaged in this discussion moving forward and maybe follow up on some of those kind of campaigny discussions that I heard starting to bubble up. And I'm going to throw one last link in here, which I hope is not too much of a stretch from today, but we had a great webinar yesterday with Gary Pritchard talking about Indigenous placemaking and ethical space. And we had a little bit of a similar conversation around one of the barriers to creating ethical space is government timelines, government imposed timelines. And so that webinar recording isn't up yet because it was just yesterday, but that will be up, and we're having 2 more conversations with Gary next week and the week after, if people are interested in that. Okay, so we're at 2:10, and I know we just want to finish up with kind of acknowledging funders and thanking everyone. But before I do that, does anyone have last comments? Was there a really key question you saw in the chat? Do you have any final thoughts you want to make sure that we cover off?
I have one thing, if I may. In my notes for today, I've got my email in there. You can track me down through the University of PEI, but if anybody out there is interested in these issues of Indigenous food security, which we're in a process of building out that capacity through the School of Climate Change and Adaptation. So again, reach out, share with, if you know anybody in your networks who wants to be part of that movement, please let me know. And thank you everyone.
Thanks very much, Charlie. Any final thoughts from any of our other speakers?
I'm just madly looking through to see if we've missed any questions.
Any really critical questions?
People wanted answered.
Probably dozens, because there's only so much time, but if you see a great one, let us know. Faye, was there anything else you wanted to say about any of the links that we put up?
They're supposed to guide you. It's not a complete list. We didn't include the link for eco-justice as a recommendation, but certainly we could do that moving forward or part of references. But we will, this series of webinars that we held was one intended to highlight the Cipa review with specific themes. And I was happy to work with Mark on organizing this with Nature Canada and our, great speakers today. And I think with hope, because there was such great reception to this topic, that we will have that continued discussion moving forward and collaborate with each other in making sure that changes to Cipa are substantive, not just for administrative purposes, but substantive that we see over the next little while, generation-wise, that the impacts to nature, to environment, and to human health from these chemicals, and certainly from biotech products are dealt with in a more rigorous way over time. So we're looking forward to engaging with people moving forward as we better understand the federal government's program to release the Cipa bill. So I'll hand it back over to you, April. Thank you very much.
Maybe I'll just jump in very quickly to say, April, we're hoping that the government will introduce amended bill this coming session, which starts next week. But of course, there's the possibility that an election will be called, and that'll cut everything short. And then if that happens, we'd love to see this become a campaign issue, that each party works on their platform around this, and then we go back into Parliament with strengthened positions from all parties.
Right, of course. Yeah, that's, I think, a perfect closing thought. Thanks, Mark. Okay, so I just want to acknowledge, you'll see on the closing screen, we want to recognize the support of the Make Way Dragonfly Fund for today's webinar and this webinar series. Also CELA's Healthy Great Lakes program, which is supported by the Mott Foundation, Canadian Environmental Law Foundation, Legal Aid Ontario, and of course Nature Canada for partnering with us. So I will just say thank you to Faye and Crystal Ann and Lucy, Charlie, Elaine, Hugh, and Mark. Thank you for your time today. And especially a thank you to our 50 participants for spending your Friday afternoon with us. Please take a moment to fill out that survey before you maybe shut down on your Friday afternoon, and have a great weekend, everyone. Thanks very much.
Thank you.
Thanks. Bye-bye.
Thank you.